Hello, everyone, and welcome to today's webinar. We will be discussing BC's new Commercial Liens Act and what it means for industry, obviously with a specific focus on towers and repairs. However, if you're a licensed dealer or someone in the collision repair industry or even glass, you're certainly more than welcome because this is all really good stuff to know. So, as I just explained, we will be recording this and posting it on our YouTube. So if there wasn't something you quite got or you wanted to reference it, it will be made available there. Dean and I, over the summer, probably into the fall, we're going to be redesigning our new impound lot operator course as well. This had been very successful in the past and instructing industry on all sorts of aspects of the impoundment process. Most of that course now is obsolete because road safety changed their program, and now with the new CLA coming in. So we'll be redesigning that. But at the end of this webinar, we are going to have a Q&A. Now, what we're going to ask for right now is, I think I will probably answer most of your questions, and I will be repeating myself quite often, but you're certainly welcome in the end to put a question in the chat box. Now, up on the top of your screen, you should see something in there that says a question or a chat. And then at the end, if we haven't answered your question and you just don't want to type it in, we can allow for some verbal questions. And for that, you'll just have to raise your hand. Sarah will have to look for you amongst all the attendees. So we might not be able to get to you, but then she can unmute you and we can ask, you can ask your question then. And then, of course, you can always feel free to contact me afterwards and we can go through, especially if you have a very specific case, we can go through it much more thoroughly. So having said that, I think we will move on. This should probably take anywhere between 30 minutes to 45, possibly an hour, depending on how many questions we get at the end. Now, this is great. Why is it working? Technology. I'm going to have to stop sharing and try this again. And not sure why this isn't working. Let me try something else. Sorry about this, folks. Give me just a minute here. Just my keyboard is not working. So I'm just going to stop sharing here. Okay. Can try this again. Okay, everyone should see that. Hopefully this will work and I can move through the slides. If not, we're going to have to do it this way. Okay, we'll have to do it this way, unfortunately. So you're going to see the next slide, but that's okay. You can just focus on the main slide right here. And I think I can whip through it then using my enter button. Okay, let's move on. So purpose of this webinar. Okay, so today we are going to be introducing the new Commercial Liens Act. And here, going forward, I'm just going to call it the CLA. And this is going to replace the older Warehouse Lien Act and Repairs Lien Act, among others. So what the Commercial Liens Act essentially does is it consolidates several other acts into one new process for towers, repairs under a modern framework. Now, there was tons of these acts before. There's Warehouse, Livestock Liens Act, Repairs Liens Act. It brings it all together. So just going through the act in all 60 sections, it can be confusing to read. So I've sort of pulled out the main sections for us. So essentially, the bill does following. It creates a new statutory lien process that replaces the WLA and the RLA, the Repairs Lien Act, which may also be registered under the Personal Property Security Act. I will explain more about what I mean by that. It establishes a priority among liens, lien holders, and other interested parties, and it establishes rights and responsibilities respecting the enforcements of those liens. So we're going to walk through what is changing, what's staying, and what you need to do in order to stay compliant. So look at the big picture and see what is changing. So after June 30th, the Warehouse Liens Act and the Repairs Lien Acts will be no more. So the lien, if you've impounded a vehicle before this date, the lien itself is still valid, but after June 30th, it's going to be enforced through the Commercial Liens Act. Not as big a deal as you think, as I'll explain. Again, even if you impound a vehicle today, it has a lien on it through the Warehouse Liens Act. It's still going to be valid after June 30th. It's just the process you follow is going to be slightly different. So let's talk, what is a commercial lien? So the relevant sections in the CLA you'll find governing this are sections 4 to 7. And basically what it is a commercial lien is a legal right to retain or reclaim goods, in our case, likely a vehicle, until payment for services is made. And to do this under the CLA, the lien must be perfected. And this is either through physical possession of the vehicle or through a personal property registration. Now, what does it mean to perfect a lien? So to perfect a lien simply means that you've taken all the necessary legal steps to document and protect your right to claim property as collateral for a debt. And it gives you priority over other creditors. That's what perfection means. So how is a lien perfected? Well, lien's perfected in basically one of two ways. The first way is through possession. So if a tow or repairer, if you actually physically hold the vehicle, you can perfect that lien through the possession of that. However, once possession is given up, i.e. you've released the vehicle back to the customer, your perfection is lost unless it is registered. And this is the second way you can perfect a lien through registration. And this is done by filing a financing statement in the Personal Property Registry. And the ARA can do this on your behalf. We have to change the site a little bit, but simply you go to the ARA website, you would go to the marketplace, you select on the Member Services tab, and it'll give you the instructions on how to do this. Now, this is important because if a lien is not perfected, it may be subordinate or even unenforceable if another party gains an interest in the vehicle. So some of the key changes. Well, one of the key changes is that possession alone does not equate necessarily with enforceability. As we just said, that lien needs to be perfected. And especially true if that vehicle needs to be, if you release that vehicle, of which you must register through the PPR. And I'll explain more of that if you didn't quite catch all that. If in possession, you must provide written notice and proper documentation. And the big thing for the towers here and for repairs is newspaper ads are no longer required to perfect a lien under the CLA. So there's no putting in the local newspaper for 2 weeks. And what I was hearing, that was getting incredibly expensive. That is very welcome news. There is a transition rule, section 66. So I said the old warehouse lien is still going to be valid. It's just that after June 30th, it becomes a CLA. So what I would say, if you're impounding a vehicle today, I just start right now the CLA process, because by the time you get to dispose of it, we're already going to be into July. So moving forward, even though it's a warehouse lien, you will just use the CLA process. And let's talk about creating a lien. How is a lien created? So section 4 is the foundational section of the CLA. So under this section of the Act, a lien is created only if services are requested by the owner, someone in possession of the vehicle, or someone legally entitled to possession. This could be, say, like a police officer, a bylaw officer, or even someone from a strata. The old Warehouse Lien Act used what was called the owner or the owner's authority. And this is basically doing the same thing. It just words it a little differently. But that's what is meant by owner's authority, is someone who has an authority to impound that vehicle or to go through the Warehouse Liens Act, or in this case, the CLA Act. A very important request must, and I've underlined must, be documented. I'm going to have a lot of questions about that, and I will talk about that. Well, so let's continue with enforceability. This is governed under section 7 of the CLA. And essentially for towers, it's going to require a written authorization from the owner or the owner's authority. And like before a repair, it's going to mean a signed work order from the owner. Both of these authorizations must identify the goods. Now, this is an important section, so I do want to read it to you so you know exactly what it says in the literal translation. So section 7(1)(b) states, the person who requested the services in relation to the goods, the owner of the goods, or another person with an interest in the goods, such as someone who has a financing statement, has given the lien holder at any time in accordance with section 2 a written authorization for the services or a written acknowledgement of the person's obligation to pay for the services. So this number 2 is likely more applicable to the repairers who have a work order. Section 2, an authorization or acknowledgement under subsection 1B must be signed by the person who requested the services in relation to the goods, by the owner of the goods, or by the other person with an interest in the goods, and include a description of the goods. So, disposing of the vehicle. So you've impounded the vehicle or your repair and the person hasn't come back to pay whatever the situation is. What the CLA states, and it really streamlines this process, says you must provide for a 20-day notice. Okay, this has to be sent to the owner and anyone who has a financial interest in the vehicle. Okay, so I'm going to go through a sample timeline, but I'm going to recommend 2 things. A, that you do an RO search, and you can do those through the ARA, because you want to make sure you are sending your notice to the registered owner. Second, you want to do a lien check, because you do not want to get to the end of this process only to find out, hey, this vehicle has a lien on it. I'm going to have to go through everything all over again. Again, there's no newspaper ad required at all. There will be a new CLA stat deck to be completed. I reached out to ICBC on this, and if there's going to be any other changes, multiple times I reached out to ICBC. They did not get back to me. I will continue trying. I think for the most part, everything will be pretty much the same. There'll just be a new deck that you'll have to fill out. That's not available online, but it will be available from the brokers. So your notice that goes out must be sent by registered mail. Now, I put a standard delivery of 10 days because that's sort of just the legal standard. So even if you mail it today, you have to assume or at least give 10 days for that person to actually receive that. And that notice is going to have to include a description of the vehicle, the amount owing, breakdown of any charges. So you can't just say in your letter, you owe us $5,000. You actually have to break out what those charges are. A statement that the vehicle has been redeemed upon payment, and a warning that if the payment is not made, the vehicle will be sold and the debtor may still owe a deficiency. You also have to include the details of the sale. So let's just go through just a really simple time frame. And it wouldn't really work out this way. I just wanted to show the very shortest path that it would take to impound the vehicle or to receive the vehicle in your shop and then to dispose of it. So let's just say June 1st, you impounded the vehicle. And on that same day, you did your RO search, you did your lien search, and you're going to send out your notices, both to the RO and then to the lien holders or anyone else. And in that letter, you have to provide 20 days notice. So you're going to have to assume, well, it's going to take 10 days. They're not going to get it till June 10th. and it's going to say the date that I'm going to sell that vehicle is going to be on June 30th. Okay. Once you've done that, then you can proceed to sell, transfer, and dispose of the vehicle. Now, this is an important note. You'll recall that under the Warehouse Liens Act, and even a little differently under the Repairs Lien Act, there's no time limit for providing written notice. So the Warehouse Liens Act used to say, well, you have to send out your notice in 60 days or the lien is void. Some people took that to mean I have to hold the vehicle for 60 days, which was false. It doesn't. It's just that was the Warehouse Liens Act. It does not say that under the CLA. So it actually does not have a time frame that you actually have to do anything with. So after the sale now, Section 41. So if there's a surplus and you've gone through and you've sold the vehicle, there's a priority. So let's just say, for example, you've sold the vehicle for $10,000. Your CLA is $5,000. There's a lien on it, and TDE is for $3,000. How it would work is you pay the creditors first. Well, first you pay yourself the warehouse lien. That's $5,000. Then you would pay the TDE $3,000, and then if there's anything left over, $2,000 would go to the RO. And you have to notify both the creditors and the RO within 30 days of that sale. And what this notice has to include, and it stipulates this in Section 41, the amount received from the sale. In this case, in our sample case, $10,000. You have to say, how were the goods sold? Well, by auction, by private sale, by lease. It's not restricting you to an auction. You can sell almost by any means, or you could buy it yourself as well. You have to describe the amount of the expenses, the care of goods, and the reasonable expenses of seizing and holding the goods. You have to describe what is the distribution of the amount received from the sale. So $5,000 for the CLA, $3,000 for TD, $2,000 to the RO. Now, if there is a question as to who is entitled, or if there's dispute, you don't have to get involved in that dispute. What you can do is pay that into the court, which I don't think many people do, but that is an option. And I think it's just a form that you have to fill out, and then they can go fight it out in the courts. For repairs, very important. And it states that specifically in the CLA, use of bailiffs. Towers themselves can't seize, or you cannot go out yourself with a tow truck or just get the car. You have to actually have authorization to impound the vehicle. So repairs, you must use a bailiff to seize, unless, of course, you have possession. Now, for repairs, what if you release the vehicle? Now, there can be a lot of cases, I think. So, for example, I can think of, let's say you have a really good customer has come in and you fix their vehicle and they say, well, I can't come in until Friday and pay you. But you think, well, they're a good customer, I'll give you the keys, just come back on Friday. Or maybe the repairs are expensive and you want to set up a payment plan with them. It's perfectly fine. Either of those scenarios, you're of course trusting that that person's going to come back and pay you. But if you release the vehicle, you still have a lien on it. But remember what I said, once you give up possession, the lien loses its perfection unless you register it. If you're going to register it, very important, you have to do it within 15 days of releasing the vehicle. You're going to need a signed invoice, which is typically a work order, and the seizure will have to be by bailiff. Okay, and we can do that at the ARA. Crystal at the ARA, I can do that. It's easy. You go on the website, there's a form, you fill out the information, easy to do. Now, what if I miss the deadline? You've waited too long and it's 30 days. You can still register and the lien may be valid. But essentially what happens under the CLA is you can lose your priority or someone can contest the lien. So that's just a warning. Try to get it within that 15 days. There's also, for repairs, there's no more 180-day limit. So before, under the Repairs Lien Act, if you registered a lien through the PPR, there was 6 months valid. And if you want to extend it, you had to go through the courts. None of that. That's all gone. So basically, it's the Personal Property Security Act governs the duration, and you can register a lien. I think it's in 3 year or 5 year increments. You would also renew it at the end of that 3 or 5 year period through the PPR. So if it's a very high value vehicle, for instance, and it's likely going to be on the road for the next 10 years, you might want to watch that because at the end of that term, it's going to automatically drop off and then you can't renew it. Okay, so this is for towers, the out of province liens, and this does happen. Let's here. So I've heard this case pop up time and time again. You've gone through all the process, you've got a buyer, you're ready to go. They go do a lien check and they come back, there's a lien on it, or there's an out of province lien on it, more specifically. So the question I always get, well, is it valid? The answer to that is a little gray area, but essentially, yes. The lien can be valid in BC if the lien is valid in the other jurisdictions. However, it must also follow BC rules. So whoever has that interest, they still have to notify secured parties, go through all of that. Now, there is a process for removing the liens. So let's say you get a situation where you've impounded the vehicle, you've done your lien check, and the TD Bank owns it, and they have a lien on it, and you want to get rid of it. The easiest thing to do, you phone the TD Bank and you say, "Hey, come get your car or pay the lien." Um, um, come get your car, pay the lien, or go after the customer. Because in BC, we have what's called seize or sue. And what that means is you can either seize the vehicle, come and get the vehicle, or you can go after the customer for the money. But you can't do both, not in BC. However, sometimes dealing with the banks, this is a very frustrating process. They don't understand it. You're not getting anywhere with the front desk person. So in BC, you can remove the lien, and there are two forms that you use. We just call them Form 4 and Form 5. They're going to be renewed. The process is exactly the same as it was. They're just going to swap out the words warehouse lien for commercial liens. They're available online at the PPR registration site. Very easy to find. It's quick Google, you can get them. Now, if the lien is in another province and you want to get rid of it, you can still do that. You just have to go through that province's process. They're all very similar. They all have their PPSA registration sites. So you just have to, I've got a list of some sites, but you might have to do a little bit of homework on your own for that. We're going to include this information in the course details as well. So the CLA has really simplified the process for impounding a vehicle and disposing of it. But I'm going to say that the key takeaway here is use written authorization forms and provide reasonable notice and reasonable charges. And my key takeaway for repairs is always get written authorization via a work order. And if you release that vehicle, register it through the PPR within 15 days. And from there on, monitor it. And if you need to renew, you can do that. Now, I anticipate, I'm not 100% sure, but I anticipate that there can be more disputes. There was always a dispute mechanism through the courts, but it was never governed under the warehouse liens. It is incorporated under the CLA now under Section 44, and it explicitly states a person may dispute the lien as concerns any of the following. The validity of the lien. I can dispute whether this is a valid lien. I can dispute the amount secured by the lien, the amount that the charges that you're applying. I can dispute the right of you, the lien holder, to take or retain possession on that. Then if the court, this is important, if the court determines that the lien is not valid, may order the lien holder to pay any financial loss to the person who has an interest in the vehicle. So this is why you just really want to know what the CLA says and what it is you're doing in case it's disputed. Care and custody, let's talk a little bit about this and what you can reasonably charge. So there's a reasonable care clause, and this is Section 24. And it simply states this, a lien holder must use reasonable care in the custody and preservation of goods in the possession of the lien holder, including taking necessary steps to preserve rights against other persons. Essentially, just what this means is that while you have care and custody of the vehicle, you have to apply all reasonable care in protecting it. And the standard for that is, well, if you own that vehicle, how would you care for it? So I'll give you an example of an actual case, and this was in BC, of a tower who impounded a Harley Davidson, parked it in their yard under, I think it was a cedar tree or a maple tree. Anyways, it had been there for a while, and sap came down and completely ruined the paint job. Of course, that went to court, and the judge found favor or against the tow operator, who had to pay for damages. Obviously, the tow operator should have taken greater care, put a tarp or not parked it there or trimmed the bushes back, whatever. However, if something happens to the vehicle that is not the fault of the lien holder, and that vehicle was not fully insured, the owner bears the risks. Okay, so that's care and custody. Associated costs. So, well, what can I charge? Well, this is governed under the reasonable costs, and it includes, it's pretty broad, reasonable expenses, including insurance, taxes, charges in obtaining, maintaining possession, and preserving the goods are all secured by the lien. So it's just a matter of itemizing that out and then applying the reasonable charges to each of those line items. I also want to touch on this, and it's called the doctrine of substantial compliance. You probably, if you've asked me, I probably have talked about this. This is under the old Warehouse Liens Act and Section 5. Essentially, what substantial compliance said is that, look, if you don't do everything perfectly, if you don't dot your I's and cross all your T's, a judge can say, well, that doesn't vitiate the sale, like the lien is still valid. You may not get as much as you want, but it doesn't negate the lien. That's all substantial compliance said. This language is not in the CLA. It's replaced in Section 50, what is called Commercial Reasonableness Clause. And it simply reads, all rights, duties, or obligations arising under an authorization, an acknowledgement, this act, or any other law applicable to liens must be exercised or discharged in good faith in a commercially reasonable manner. It's commercially reasonable. And what that means is simply, it's on the next slide. No, that's not. Commercial reasonable is just what is the industry norm, what is the industry standard or practice, and that's just what a judge would rely on to determine, are you acting in good faith? Is this reasonable? Now, if you are challenged, the owner or the owner's authority or whoever is contesting the lien can demand information from you, and you have a legal obligation to provide that. So under these sections, 25 through 29 discuss this. And basically under section 25, someone can make a written request for information about the vehicle and the lien to you. You, tower, repairer, will have to respond within 10 days. And the request can include things like a copy of the authorization or your acknowledgement, the tow request, basically, the amount owing and payment terms, a list of goods, in this case, just the vehicle, but you have the right vehicle. And if the tower fails to respond or the response is incomplete, the requested party can apply to the Supreme Court to compel compliance. And a judge can say, well, the tower can be penalized. The court can order the lien extinguished. It can just order you to respond, or he can also impose other consequences. Now, when you do respond with the information, you are also legally bound by that information. See, whatever you put in the writing and send it out, and then it goes to court, that's the evidence. You can't later deny it. So be sure that you send out the correct information. Anyone gets a free every 6 months is basically what the CLA is saying. But if I have multiple demands within that time frame, or by 12 months later I do it again, you can charge a fee. But that fee can't be very much. It has to be in line with whatever would be governed under the PPSA, so like $10 or $15. Those are all the relevant sections of the CLA. So it's quite a bit simplified, but you also want to really understand what each of those sections says, I think. So we're going to open up to some questions. I'll stop sharing my screen. And hopefully I've answered everything, but so I will turn to Sarah. Have any questions come in?
Yeah, we have a question from Dave.
Mhm.
He says, in your example of the notice to the owner and the 20-day requirement, just to confirm, 10 days may be lost for registered mail delivery. Does
Yeah.
this correctly become part of the overall 20-day minimum requirement?
No, what I'm suggesting, now the CLA, when you read the actual language, is a little vague. However, 10 days is the standard. So when you mail that out, you allow for 10 days. And then the 20 days starts at that period. So June 1st, you send your registered letter out. You're going to assume that they receive that letter and read it on the 10th. And when they read the letter, it's going to say, hey, if you don't come pick up your vehicle in 20 days from this date, then we can sell it, which would be June 30th. So I hope, does that answer, hopefully that answered Dave's question.
So we have a couple more questions coming in here, but
Okay.
another Dave has his hand up. Am I good to proceed with unmuting him so that he can
Go,
ask his
yeah,
question?
go ahead. If I haven't quite answered, I know typing can
All
get
right.
a little stale. So
All
go
right.
ahead. You can unmute Dave and if he needs to follow up.
All right. Dave, you have your hand up. You can unmute and ask your question.
Don't you have to unmute him, Sarah?
I did unmute him. He just has to unmute on his side.
Oh, okay.
Yeah.
Dave, if you go up to the top, there should be a panel in there and you'll see a little mic icon.
Hey there.
Hey, Dave.
Hear me? Hey,
I sure
Candace.
can.
Steve from Jack's.
Yep.
Two questions, quick ones. Is there any time limit that you have to notify by? Like it used to be within 60 days. Is that still valid?
No. So that's a fundamental difference. There is no time limit.
So if you have a
Um,
Ferrari, you can wait 5 years and then tell the guy you got his
no.
car?
Well, you can, but I doubt that's going to stick. Um, no. So there is no time limit, but if someone disputes it, you have to defend why it took you so long to act. It's what it is. Now, there can be some cases. So for example, we do know that some people say, come here, driving a Ferrari, they park in a strata, they go back to their home country, and they must have money to burn because the car is out of sight and out of mind. And some towers will do multiple responses or sit on it. You can certainly do that or try that. Um, but it could be easily disputed because there is no obligation. There's just the one notice.
Okay. And the other
You're
one I had
also,
is, sorry, go ahead.
well, I was also going to say as well, you got to be a little careful because anything can happen within that time. Someone can put another lien on it and screw that up. They could transfer it or something. Like a lot of things can happen within that time frame. So
Yeah.
go ahead.
The other one was about the out of province liens where we're supposed to notify and force a lien off out of province. Is
Yeah.
there going to be a mechanism in place to get an RO search or equivalent from other provinces? Because I find that
The
very hard once it's not in BC to have anyone tell us who owns the car.
Yeah, so for the ROs, we did publish a paper that the towing division sponsored and MNP did it, and it gives the process for every province in Canada, and as well as a few of the states. The states are actually quite simple and they're all very similar. Um, so for the liens, the ARA can do some lien checks in Ontario, and I forget, I can't do every province. Um, that can get cumbersome because if every time you got an impound, you don't want to be doing 10 lien checks.
Yeah.
And it's also a lot rare. So it's just if it does pop up, like when you go to sell it, and then whoever you're selling it to does their own lien check and it pops up, hey, there's a lien on in Ontario, you just have to deal with it. And each province will have, we're going to publish some of the links to some of the pages if I can find them. I don't know if I have them for all 10, but I have them for a few provinces. So does that Does that
Yeah,
answer?
I think that's got my questions. And I guess authorization from police is just a file number. We don't need to have an officer physically sign a form or anything.
Well, I'm sure Sarah, I probably got some questions on that. Are there some other questions up ahead? Because I can deal with that right now.
I was just going to reiterate that one, Ken, because we had talked about that. Same thing
Yeah.
applies to private impounds. If you're doing a private impound, if you need a individually signed notice for each vehicle or not.
Yeah, so that hasn't been tested yet. And on its face value, it says a written authorization that gives details of the specific vehicle. So what I would say is most police, they give a notice of impoundment. So you do already have something signed there. If it's a strata, you could record the dispatch calls and you could just make sure that whoever's on the other end saying, identifying themselves, hey, I'm so and so from this strata, and I want you to pick up this car, license plate number, VIN number, whatever identifies the vehicle. Where it can get a little murky is with phone calls. If it's not recorded, somebody's just called you up and said, hey, come pick up this car outside my store. It's a green car. I don't know what it is. That's probably not very good because remember, I can summon you for that authorization and you would have to prove it in court that you were authorized to impound that vehicle. Dina had also brought up the issue of patrolling. This can be another gray area. So let's say you just have a contract and it says, well, you just drive around and if you see someone who's illegally parked, just go impound them. That would depend on whether a judge would interpret that and say, I'm delegating my authority onto you, whether that would fly. I'm not sure. That hasn't been tested yet. So I would say I would review your process with police, with stratas in private or anyone else, and just make sure that you're getting as much documentation as possible to justify that. No, I was legally authorized to go and impound this vehicle. Okay.
What about for those RCMP calls where you don't get a paperwork for?
Do you record the call?
Some towers probably do and some don't.
Well,
Would a file number be
a file
written?
number, anything that I think would document your authorization to do that. Like you can't just be driving around and I'm going to impound that car. That's not going to fly, right? So it has to document that it was actually illegally impounded, that you had the right to do it, and that you were authorized, again, by the owner, which in towers cases, that's the owner's not going to call you, but the owner's authority in this case. So you're going to have to review that and look at your processes, because if all it's doing is resting on some loose phone call, yeah, Tom called me and told me to pick up this green car. That's pretty loose. So that's all I can really say about that. Sarah,
Perfect.
I don't know if
All right,
hopefully I've answered that. We can take it offline and get into some real specifics and maybe strategize for how we can do this. So,
all right, so we have a question from Nicole.
okay.
How long does it take to process a Form 4 and a Form 5?
Good question. Dina, you know this, don't you? Do you remember this?
Yeah, it goes back a little ways. That's part of the whole entire process that we're going to be doing the new course
Our
on.
new course on, yeah. So what it is, Nicole, is there's a Form 4, and what this is let's say you've called your bank, because that's the easiest thing to do. You've called TD Bank and you get somebody in the front counter and no, we're not going to do that. Okay, so you take Form 4, you fill it out, you send it to the registering, or not the registering party, the financing party, with like TD Bank or whoever the bank is, and it's saying remove the lien. And they have to respond within 45 days. And let's say you can't get anywhere. What you then do is you then take your Form 4, you fill out Form 5, And then you send both of those to the PPR, to the registry, and they say, look, these guys aren't cooperating, remove the lien. And that can take, well, that can take anywhere from 10 to, I think, 30 days, maybe even longer. There is a slight chance of two things happening. Both have happened before in the past. The first thing is a bank can just put the lien back on. This is very frustrating, unfortunately. And you've got to go through the whole process again. It doesn't happen a lot, but it does happen. The other thing that can happen is the banker, whoever the lien hold, the secured party is, can take you to court. And then, because it's really ultimately only a judge that can remove the lien. But those things don't happen very often. I hope that answers your question, Nicole. Sarah or Dina, do we have any other questions? Either or.
We have quite a few.
Okay, I'll try to get through them all.
Does the CLA stat deck, I'm assuming it means doc, have to be notarized?
Good question, and I've been trying to get a hold of ICBC on that. I'm going to say yes, that is the process. I want to get hold of ICBC just to ensure that that's an actual policy, because I think we found that it's a little loosely applied depending on which broker you go to, and we believe it should be consistent across the board. So I'm going to say that nothing's really changed other than a new form from whatever you were doing before. But hopefully I can get a hold of someone in ICBC who can actually answer that question definitively. Okay.
All right, next
And
question.
yes, please.
Will the ARA provide a sample letter in regards to the CLA? If so, what time frame?
We will. I think the old course is taken down, if I'm not mistaken, because it was so we had sample letters in there. It's very easy to do. We're just going to take the same letter and just replace warehouse lien with Commercial Liens Act. So yes, we will, and we'll include those in the course for your download.
We have a question from Stella. Says, does the CLA apply to out of province vehicles, and is it the same process?
The CLA to out of province. Yes, it is the same process. You would just have to deal with it. Yeah, so you still have to notify the RO. You still have to take possession of it. There's some other things you have to do before you get it transferred. So if it's from another province, it has to be inspected provincially before you can register it in BC. You could sell it as an Alberta vehicle, but it couldn't. But in order to register in BC, it has to go through an inspection. So there's some additional things that you would have to do. But yes, doing the ROs in Alberta are probably the most trickiest province. Our guidebook that we published, and it's available through Tow Canada right now. We are going to incorporate it in the course, but you can get it if you go onto your Tow Canada subscription page and download it. Alberta, it's very possible. It just has to be done through a third party, and the timeline has to be fairly quickly. So if you recognize it is from Alberta and you know you're going to have to go through that process, get right on it. Don't wait. Okay. And that question.
Am I good to just keep going with the questions?
Yeah,
here?
keep going. I don't know if I'm answering them to, but anyone can always reach out to me.
Perfect. Well, we have a question from Jennifer. Jennifer's asking, is an RCMP's officer name and file number or bylaw officer name and ticket number enough to qualify for authorization to tow?
I would argue yes. I think so, because a file number can be referenced, right? It's coming from a police authority, so I think that holds a lot of weight and stuff like that. So I think you could successfully argue that qualifies as proper authorization and notification under the CLA. It's when it comes to private, again. So if I'm disputing the lien, okay, and I'm taking you to court and I'm arguing, I can argue a lot of things. I could argue you're charging me too much. You didn't go through the process, but I could also argue that you did not have authorization. So if I request information and say, okay, I want the authorization, Like, you have to provide that to me. And if all it is a phone call with no verification, you say, well, sorry, it was just a verbal phone call. Well, what's that going to rest on? That's just going to rest on a judge. Well, I believe this person or I don't. So that's why I think you really want to review your steps in your process. Like, even if it can be an email, I would probably insist on that. But until they're tested, we don't really know 100%. So keep going.
All
Sarah.
right, we have like a good 6 more questions here.
Okay.
So,
Well, we have time.
Tyson is asking, would an email work for written authorization?
Yeah, just as I sort of answered before, I think an email, because even though it says written and signed, the courts have accepted digital signatures. I mean, you can get a mortgage, I think, just online now these days and stuff. So I think that would hold, because it's at least it's verifying that you received an actual notification from somebody who is an authority. Dina. Oh, you're on mute there.
Sorry, I'm getting messages through text as well. And I'm being asked right now, if you sell a vehicle with a lien on it, and you send the overages to the lien holder, do you still need to force the lien off? So for example, if a bank is owed money and we sell the vehicle for $10,000, our lien's $5,000, can we just send them the $5,000 and not force off the lien?
Yeah, yes, you can do that. They should remove the lien. Like, if you pay out the bank, yeah, they're supposed to remove the lien.
Is it up to us to force them to take it off?
No, they should do that. I mean, if you've paid out the lien, they should take it off. I can't imagine a scenario where they wouldn't. I mean, hopefully you don't get that. That would not be cool. I mean, you've paid them off, and they won't remove the lien. That's like, I don't think that would happen. If it did, yeah, you would have to go through the Form 4, Form 5. Some banks can be jerks. I would not put it past, let's say I wouldn't put it past them. But for the most part, I think if they're paid out, they should remove the lien. Okay.
All right.
Sarah or Dina, if you had any other.
I
We have
have
about
a
10
question
minutes, so.
from Emily.
Uh-huh.
Emily's asking saying, most of the time we cannot do RO searches and lien searches out of province. So how can we force the lien off? The PPSA is different from the BC ones. She's tried before, and BC registry cannot discharge the lien.
So they cannot discharge an out of province lien. So doing an RO search, we can do them in BC. For any BC registered car at the ARA. That's easy to do. Crystal at the office will set you up if you're not already. Most of the towers are doing them. Repairers can't do that, but you don't need to. And if it's a BC registered lien, you can use the Form 4 and Form 5. Now, if you have to go out of province, we did publish the RO search guidebook. Right now, it's on the Tow Canada website. We're going to incorporate it into the course that Dean and I are working on. But you can go online, and it gives for every province how to go about doing it. The only real tricky one is that Alberta one, because you have to go through a third party, and you have to be very quick with it because there's a limited amount of time. Then if you have to, if say you've got a lien and it's from Alberta or Ontario, they have a similar process as to BC, but you have to go through their process to remove it. And generally those only pop up is if you've impounded the vehicle, you've got a buyer, he's ready to take ownership of it and pay you the money, and then he does a lien check and he finds out there's a lien on it from Alberta. And he won't want the car because it's got a lien. So you have to deal with it. I mean, technically, he could still buy it with a lien in Ontario but it's probably no one's going to really come and do anything. But however, it's the stigma of it. Dina.
Another question. If we send out a registered letter to notify the owner of a vehicle that's in the yard, and the letter is returned to us as undeliverable, can we dispose of the vehicle early, or do we still have to hold on to it for the 30 days?
You still have to, very good question, but yes, you still have to hold on to it for the time period. Yeah, because somebody still could find out through their brother, or they could come back from their holidays and where's my car, and then find out it's been impounded. So yes. But you don't have to, you're not obligated to chase anyone down. So if that letter comes back, that's why you want to do it registered. You don't have to send out multiple notices. Like one notice, that's it. And this is what I mean about the storage. Like if you're like Dave asked, is there a time frame? Oh, great. So we could hold on to it for a year. Well, potentially, but you can't say, judge say, well, why did you hold on to it for years? Well, I was trying to track down the customer. That's probably not going to necessarily fly, right? Because you only have to do that one notice. That's it, and it's up to you for anything extra.
And building on that, we had a conversation about this too. If a tower makes a mistake administratively or doesn't notify somebody, what are the penalties?
Well, that's a depends question, and that's going to be what a judge decides, and it's going to depend on what is the mistake. So, as you recall, in the old Warehouse Liens Act, you had that substantial compliance section, and that was basically saying, hey, you didn't do everything right, but the lien still holds. What it says in the CLA is what is commercially reasonable. And I think if a judge thought, well, you're being reasonable in it, but you screwed up a few things, they're not going to really hold that against you. It could be that he says, well, the liens hold, but you're saying the lien is $10,000 and I'm going to dispute that and only give you half. That could happen as well. Okay. Sarah.
Alrighty, so let's see here. With respect to written notice, please do not give us written notices for no insurance or abandoned vehicles. So I guess that was a comment by Dan Bird. Stella is asking, would private impounds that are already in the system still need a tow-away notice to be signed retroactively?
Okay, I'll deal with both. Let's deal with Dan. I think Dan is saying like an abandoned vehicle. Well, one, it depends on who is requesting the services. So if it's an abandoned vehicle on a highway in the Ministry of Transportation, they are supposed to, even according to their own procedures, provide some kind of a ticket or a notice, and they're actually supposed to put it on the car. So I would question how they're going about doing that. So you need something. If it's just a municipality, I would check your process with that municipality. Like, are you comfortable with just accepting a verbal phone call? And if you are, great. But that could be challenged is all. So that's what I would say. Hopefully that answers with Dan. Now, can you repeat Stella? I don't know what did she ask?
Stella's
No.
question is, would private impounds that are already in the system still need a tow-away notice to be signed retroactively?
Okay, I'd have to talk because I don't know what she means, a private impound in the system. Is she saying that you've been patrolling and you've gone and picked up a car and then you've been asked for to the authorization? Could you go to the strata and say, hey, send me something? Well, I suppose you
can. I kind of check it like if she has a vehicle in her yard right now,
yeah.
that was towed and she didn't have anything signed for it, does she have to get something signed for it now to proceed? That's my
Through the
interpretation of it.
CLA after June 30th. Only if you're going to be challenged on it at this point. like if you don't think you're going to be challenged on this lien, I don't think I would worry about it. But if you're going to dispose of it after the end of this month and we're into July, then that's going to fall under the CLA, which does require, it says, written authorization. So if just to protect yourself, yeah, you could go to the strata or private and just say, hey, send me an email that you authorized me to take this car. That's you could certainly do that, and it would just protect yourself. You have something. Hopefully that's what Stella was asking. And if I haven't answered that, Stella, you can give me a call later and we can go through it. I don't know everything, so I'm still kind of learning myself as well. Well, we have 4 minutes left. Sarah, is there a couple more questions on the table?
We have 5 questions left, and well, 6 questions left in 4 minutes. So I'll try to be quick with these.
Something that maybe something that we haven't answered.
Let me take a look here. Can you sell the vehicle with a lien and then just send the creditor the overages?
Yeah, so you could do that. You're going to have to get all the parties to agree on that. So you've sold the vehicle, and you told the customer, well, don't worry about the lien. I'm going to pay out the creditor, and they promise to remove the lien. And if they're happy with that, the terms of the sale, I think that should be sufficient. As long as everything's documented and upfront, I think that's good. I had a verbal question. Mike, I see, does have his hand up. Sarah, do you want to just unmute him? And
absolutely. So, all right, Mike, you're able to just unmute yourself at the top bar of your on your screen.
Yeah, no, I just asked a question a little earlier in the meeting chat. Can we register a lien on a tow? So if we're doing a long haul tow, say from the North Island to the South Island, we're releasing this truck to the shop or wherever it's going to. Can we register a lien within that 2-week time period if they haven't paid within a few days?
yeah, you could actually. Yeah. Because a commercial lien can, remember, it's perfected either through possession or through a PPA registry. So yes, you could do that. I couldn't imagine. I was thinking, Dean and I were talking about this. I thought, I can't imagine a case where a tower is going to release a vehicle. But I suppose it could happen, and technically,
it could
yes,
happen.
Yeah, you could do that. Yes, you could do that. You could be just, that's kind of like, that's sort of what repairs are doing. I wish I don't know if there's a lot of repairs on this call. They need to be, because they're constantly doing this. I get a call and I tell them to register the lien, and oh, I never bothered. It's like, well, why didn't you just register within that time period? You would have saved yourself a lot of hassle.
Yeah, we just run into situations where middle of the night they can't get hold of their office to get a credit card or whatever. So you kind of do the okay, we'll work with you, and then the next thing you know, you're chasing them.
Yeah, you could. So yes, theoretically, you could do that. So good to know that actually occurs. Dina.
I was just going to point out there's a couple of questions, Sarah, in the chat section as well. Somebody's asked here, after a person has gone through the process to perfect a lien, how would they go about obtaining registration?
So once they've given the notice, you've sent your registered letter out. You've said, hey, in 20 days from the time that they would have read the letter, we are going to sell it, and you sell it. You've done everything perfectly. Then you take all that to your broker. You fill out that CLA form, and ICBC is supposed to transfer it. I reached out to ICBC. Is there anything else? They haven't got back to me after multiple times. I'll keep trying, but I think for the most part, not much is going to change from how you did that before. You can run into these situations. I don't know if this is one of the questions, but I do want to state it, because we've had some issues. I think I can't remember. I think it was Tyson and I were talking the other day. What happens if somebody sells the vehicle in the interim? Then you go to the broker, and ICBC says, No, that's not the registered owner. And they, well, what do you mean? We did a registered owner check through the ARA and it said Bob Smith and here's his address. And they go, no, it's this person. You get those situations sometimes. So it
And
can happen.
David from Buster's was asking if a lien expires, do you still need to go through the Form 4, Form 5 process?
No, if it's an expired lien, it's an expired lien. No, it's done. Or if it's near expiry too, because check the date, because there's a registering date and they're good for 3 years. However, keep in mind though, if it hasn't expired, a bank can renew it. They just renew them automatically. Okay.
We still have a few more questions here. Do you want me to read them out or?
Yeah, let's go through them quickly. We are
Okay.
running, we are past our hour, but if people are engaged and they want to discuss this, there's a lot to it. It's easy, but there's also a lot to it. But yes, go ahead. Let's go through the remaining questions.
I don't know if I've already read this question out loud. If I have, I'm sorry. But if the RO is deceased, can we get rid or scrap the vehicle right away if we don't need to advertise it anyway?
No, it follows the same process. It just a deceased, it's whoever's the what's it called? Who handles the estate of somebody. Yeah, it goes into the estate, whether it's a person or the court. So no, it still has to follow the same process.
All right. Nicole is asking, is there anyone to contact to find out the status of a Form 4 or a Form 5?
Has anyone been?
Is there anyone to contact to find out the status of a Form 4 or a Form 5?
Yeah, so with the Form 4, because that goes to the bank or the financing company and you haven't heard anything, you can always follow up with them and say, hey, I sent you this Form 4, I need this, and see what they say. So, if it's gone, it's 40 days or 45 days, I forget the exact amount, and it's now in the Form 5 stage, you can contact the registry and say, hey, I've got my Form 4 and Form 5. It's been 2 months and I haven't heard anything. Yes, you can contact them and they can tell you. Yeah, because it does happen. They get backlogged. It's not always quick. Okay.
Dave is asking, can you register a lien if a payment on a tow is reversed?
Can you register a lien if the payment?
I'm understanding that to be if you take a credit card and it gets rejected, it gets sometimes they can be fraudulent cards that are used or
Oh, yeah.
Somebody's gone back and contested or canceled a check or whatever type of payment.
So really good question. I would say yes. Yes, you could because you've released the vehicle. You've collected payment, but it's like writing a bad check that that disregards whatever that was. And yeah, you come back. It's like somebody writes you a check and you go to the bank and it's insufficient funds. Go register a PPR. You could do that technically. That's kind of like Mike's questions. I released the vehicle and do I still have time to register a lien? I would say yes, you can do that.
Does that have to be done in that 15-day period? Or
well, it's the 15 days just simply means is that if you want to maintain your priority over other creditors, and if you're late, you don't necessarily, you lose priority. So if there's already a lien on it by the TD Bank, they would have equal right as you would. And how would that be settled? The only way that could be settled is by the courts. Or you come to some kind of a mutual agreement. That's what the 15 days is. So you can still register it after the fact. You just legally lose your priority. That's all.
All right.
That's a good question.
Rob's asking, does a signed tow slip for a private impound constitute a written authorization form?
Signed tow slip. Well, it would. As long as the tow slip has some basic information that it's someone who is authorized to sign that, like a strata or a bylaw or a police or someone, a store owner, you know, you parked in front of their store illegally or whatever, and as long as it contains the vehicle details, you know, 2015 Ford Mustang, license plate, blah blah blah. So it properly identifies the goods.
All right, and now just two more questions, comments here. So Jonathan is asking if this video will be uploaded onto YouTube so that he can show another one of his staff members.
Absolutely, yes. It's being recorded. We are going to post it up on YouTube, and then Dee and I are going to be working hard over the summer. Maybe not that hard. We do want to fit in some vacation, but we want to get that course up as well, and then we can put some other tools and resources and things like that. So yes, absolutely.
He's asking what will it be called so that he can find it.
How about navigating the new Commercial Liens Act? I think that's a good name.
And when will it be up?
Oh, I've a week. I think it's pretty easy. Just has to be recorded. I don't think it needs any editing, but we'll have to kind of look at that, and then whoever uploads that, I think Burhan uploads that. So pretty quick, within a week.
Comment from Dave Ribeiro. He said, "Ken, a great session with multiple questions. Perhaps we can post a Q&A to better package the questions and develop a direction to clear up any confusion." I guess that's something.
Yeah, we'll certainly do that with the course. Absolutely. Yeah. But hopefully for right now, I've got you all prepared. And hopefully you know enough now that you can get started and get navigating post June 30th. Please feel free to reach out to me with any additional questions, or if you're unclear or I haven't really answered your question, please feel free to contact me and I'll go through it with you. It's actually, yeah, as I said, it's actually a very simplified process. So it's sort of, as long as you follow it, you will be fine. I think that's it. We did pretty well on our time. I want to thank everyone for attending today's session, and best of luck.
On behalf of industry, Ken, thanks for putting this together for everybody.
Thank you. Good. Okay, we will talk to you all later. And I think there's still some room for our social, isn't there, Dina?
Yes, Thursday night, if anybody wants to come
so
up.
we're having a social. We got a good crowd coming out. I think we have just about 40 people. But I think the room holds a little more. So registrations are still open. Come on out. I'll talk your head off of the CLA too if you want. So
yeah, if you need any information, just reach out to Ken or myself.
Yeah, you absolutely. Good stuff. Cheers, everyone.
Bye.
Bye.